Hi everyone, my name is Beth Brown and I am counsel in the pensions group at Mayer Brown. Welcome to this episode. In these episodes, we cover different topics each month, providing an overview of the issues faced by pension industry practitioners and offering some practical insight. Time spent listening to these episodes can count towards solicitors' continuing competence and PMI CPD requirements. All the episodes are available on our Mayer Brown YouTube channel, as well as iTunes, Google Play and Yahoo. You can also subscribe to this channel so that new episodes are shown automatically in your subscriptions feed. Hi everyone. Some of you may remember that back in March I talked about the new climate change risk reporting requirements set out in the draft regulations which were being consulted on. This consultation has now closed and the government has published its response, which is what I'm going to talk about in this episode. Before summarising the requirements set out in the new regulations, I'll just give you a bit of a brief refresher to set the scene. So back in 2016, the United Nations Framework Convention on Climate Change saw the Paris Agreement, which covers climate change, signed. With this in mind, the Pension Scheme Act 2021 introduced a framework in respect of governance and reporting requirements for climate-related risks. Essentially, trustees will be subject to new requirements to ensure that they have in place effective governance in respect of the effects of climate change. The details of these requirements are set out in two sets of regulations, being the Occupational Pension Schemes Climate Change Governance and Reporting Regulations 2021 and the Occupational Pension Schemes Climate Change Governance and Reporting Miscellaneous Provisions and Amendments Regulations 2021. I'm just going to refer to these collectively as the regulations. The government has now published the finalised regulations and accompanying statutory guidance. The requirements under the regulations are essentially unchanged from the consultation version, and the changes that have been made are largely technical and designed to clarify aspects of the requirements. Changes have also been made to the statutory guidance to provide further clarity and support for trustees. Now the regulations have been finalised, trustees should start thinking about what is required of them. The regulations require trustees to, firstly, have knowledge and understanding of the principles relating to the identification, assessment and management of climate-related risks and opportunities affecting occupational pension schemes. Secondly, establish and maintain oversight of the climate-related risks and opportunities which are relevant to their scheme. The third point I'm going to talk about demonstrates that the requirements go beyond what the trustees themselves are doing, as trustees are required to establish and maintain processes for the purpose of satisfying themselves that anybody who undertakes governance activities on their behalf, advises them on governance activities or assists them with governance activities, also takes steps to identify, assess and manage any climate-related risks and opportunities which are relevant to the governance activities that the person is undertaking, advising or assisting with. Also, on an ongoing basis, trustees must identify and assess the impact of climate-related risks and opportunities which they consider will have an effect over the short, medium and long term on their scheme's investment strategy and, where applicable, funding strategy. Trustees are also expected, as far as they are able, which I will come on to in more detail in a minute, to undertake triennial scenario analysis, which includes considering at least 2 scenarios where there is an increase in the global average temperature. So I said I'd come on to what the requirement to do something as far as they are able means. What it means is that trustees should take all steps that are reasonable and proportionate in the circumstances, taking into account the costs or likely costs which will be incurred in taking those steps and the time which will be required to be spent in taking those steps. The regulations are not expecting trustees to spend a disproportionate amount of time and money in taking the required steps, but it is expected that trustees will do everything they reasonably can do to comply with the new requirements. Before moving on from this new requirement, it is also worth noting that in the intervening years, trustees must review whether circumstances require them to refresh their analysis. The first scenario analysis must be carried out in the first scheme year in which the scheme is subject to the governance and reporting requirements. Trustees must also establish and maintain processes for identifying, assessing and managing climate-related risks which are relevant to their scheme. In light of the fact that climate change is not a standalone matter, trustees will need to ensure that the management of climate-related risks is integrated into their overall scheme risk management. Trustees will also have to select a minimum of 2 emission-based metrics and 1 additional climate-related metric. As far as they are able, trustees must obtain the data required to calculate their chosen metrics on an annual basis and use the metrics they have calculated to identify and assess the climate-related risks and opportunities which are relevant to their scheme. Trustees are required to set a target for their scheme in relation to at least one of the metrics which they have selected and, as far as they are able, measure the scheme's performance against that chosen target annually. And finally, as you would expect, there are some new reporting requirements. Within 7 months of the end of each scheme year, trustees must produce a report which is often referred to as the TCFD report. This report has to set out various prescribed matters relating to the trustees' climate-related governance, strategy and risk management processes. The report must be signed by the trustee chair and published on a publicly available website which is accessible free of charge. It's worth noting that there is statutory guidance which accompanies these new regulations, which trustees must have regard to in complying with their climate-related risk, governance and reporting requirements. The guidance helpfully provides an overview of the requirements on the regulations and then offers guidance on what trustees should do in order to comply with them. Now we know what has to be done, the next question you'll probably want answered is, when does this all need to be done by? The requirements are going to be phased in, so they apply to the largest schemes first. From the 1st of October 2021, all occupational pension schemes with relevant assets of 5 billion or more will need to comply with the new requirements. Authorised master trusts and collective money purchase schemes will also be subject to the requirements from the 1st of October this year, regardless of their asset level. Then, from the 1st of October next year, all occupational pension schemes with relevant assets of between 1 billion and 5 billion will need to comply with the new requirements. For the purpose of these regulations, when we talk about the relevant assets of the scheme, what we mean is the scheme's net assets as recorded in the audited accounts for the scheme year ending on or after the 1st of March 2020 for the first tranche of schemes in scope, and on or after the 1st of March 2021 for the second tranche of schemes. Please note though that some of the assets are excluded when calculating the scheme's relevant assets. This is assets such as bulk annuity policies and certain other insurance policies. Where an occupational pension scheme has relevant assets of 1 billion or more for a scheme year ending on or after the 1st of March 2022, the scheme will become subject to the requirements from the scheme year, that is, 1 scheme year and 1 day after the scheme year end date. If trustees do not comply with these new requirements, the pensions regulator will be able to use its powers to enforce compliance, including the ability to issue fines of up to £5,000 for an individual trustee and up to £50,000 for a corporate trustee. If you're a trustee of a scheme that will be subject to the requirements this year, you should continue to work towards establishing arrangements to ensure compliance. If you are a trustee of a scheme that will be subject to the requirements next year, I would still recommend that you start making preparations now, as a lot of these requirements will take time to comply with. For this reason, even trustees of other schemes which are not yet required to comply with the new requirements under the current regulations may still wish to consider the extent to which they should voluntarily comply with some or all of the requirements as a matter of good scheme governance. Thank you for listening. This episode is an overview of the law in this area, and how the law will apply in any particular case will depend on the individual circumstances. Please therefore remember to seek legal advice on your particular circumstances.